Bismillahirrahmanirrahim. Assalamu alaikum and hello to everyone. Students, today is the seventh week of our course, and now we are in the middle of the our course. We have started our journey 7 weeks before, in which we have started to learn the international criminal law. So now, students, as today's lecture is very much important and very interesting. And okay, so without wasting further time, I'm going to share with you today's slide and lecture scheme. So, students, this is the course of international criminal law, and today's lecture topic is the International Criminal Court, ICC. ICC, it doesn't mean ICC means ICC also famous for the International Cricket Council, but in here we are going to discuss the International Criminal Court, which also called ICC. So here's the lesson plan. As usual, our lecture is divided into two lessons. In the first lesson, before break, we discussed the lesson 1, and after the short break, thereafter I will start the lesson 2. So these are the very important topics regarding the International Criminal Court. I have divided in lesson 1 topics and lesson 2 topics. So in first lesson, students, we are going to discuss the introduction and history and judicial nature of the ICC, and the establishment of the International Tribunal, and the establishment of an International Criminal Court, and organs and organization. So students, now here is the first topic of today's lecture. My lecture is beginning with the topic introduction, history, and judicial nature of the International Criminal Court. In the aftermath of the Nuremberg and the Tokyo War crimes trials, the international community acknowledged a need of establish a permanent international criminal court in 1948. The International Law Commission, hereinafter ILC, was assigned to work on this project. The results of the ILC work laid the foundation for the formulation of the statute of the ICC, hereinafter ICC statute. So at the same time, the international community was learning from the two ad hoc criminal tribunals whose experience assisted in the creation of the statute. So what was the aim and work of the ILC? After the Nuremberg and Tokyo War crimes trial, the UN started a process towards the creation of a proposal to establish a permanent international criminal court was discussed during the negotiation on the 1948 Genocide Convention. In the end, Article 6 of the Genocide Convention only invested the future establishment of an international penal tribunal, which is as under the persons charged with the genocide or any of other acts enumerated in the Article 3 shall be tried by a competent tribunal of the state in the territory of which the act was committed, or by such international penal tribunal as may have jurisdiction with the respect to the contracting parties which shall have accepted its jurisdiction. So this was the Article 6 of the Genocide Convention. Then, the United Nations efforts towards the creation of the Permanent International Criminal Tribunal encompassed, planned, and designed, on the one hand, the codification of the international crime, and on the other hand, the elaboration of a draft statute for the establishment of the international court. The main body involved in the drafting process was the ILC, a body of experts nominated by the General Assembly, charged with the codification and progressive development of the international law. In 1947, the ILC was asked by the General Assembly to prepare together with the Nuremberg Principles a draft code of the offenses against the peace and security of the mankind. The final version of the code with 20 draft articles constituting the code of the crimes against the peace and security of the mankind was adopted by the ILC only in 1996. The delay was caused by a disagreement on the definition of the aggression. Upon receiving the first final version of the draft code in 1954, the General Assembly postponed the consideration of the draft code until further work is done on this question. The ILC continued its work on the draft code after the definition on aggression was adopted by the consensus by the General Assembly in 1974. However, the process resumed at the General Assembly request only in 1981. In 1950, the General Assembly set up the Special ILC Committee on International Criminal Jurisdiction, consists of representation of the 17 member states of the United Nations. The committee's task was to prepare concrete proposal for the establishment of the International Criminal Court that could administer the code of the crimes against the peace and the security of the mankind, which the ILC was simultaneously drafting. The ILC, International Law Commission, produced the first draft statute for an ICC in 1951 that was revised in 1953. The draft statute was permanently shelved due to the lack of progress of the definition on the aggression and the draft code. In 1989, towards the end of the Cold War, the General Assembly once again requested the ILC to address the question of the establishing an international criminal court. The General Assembly's decision to revive the idea of the International Criminal Court followed the initiative by Trinidad and Tobago to establish a special criminal court to deal with the problem of the drug trafficking. In 1994, the ILC adopted the final version of the draft statute for an ICC. The draft only dealt with the procedural and organizational matters, thereby leaving the definition of the crimes and the associated legal principle of the Code of the Crimes adopted by the ILC in 1996. The ILC recommended the General Assembly to convene an international conference of the study the draft statute and conclude a convention on the establishment of the International Criminal Court. Subsequently, the General Assembly decided to establish an ad hoc committee open to all members of the United Nations with the mandate to review the major substantive and administrative issues arising out of the draft statute and to consider in the light of the review arrangements for the convening of a diplomatic conference. The committee met twice in 1995 and was then succeeded by the preparatory committee established by the General Assembly in 1995. Both instruments, the draft statute of 1994 and draft code of crimes of 1996, played an influential role in the preparation of the ICC statute. The draft statute of 1994 formed the initial working document first for the work of the ad hoc committee and later preparatory committee in the years of 1995 and 1998 is for the code of the crimes of the 1996. It was not fully incorporated in the draft statute, but it was used by the preparatory committee as appropriate. Thereafter, students, in 1995, the General Assembly decided to convene a preparatory committee inviting participation of member statutes of the UN non-governmental organizations and various international organizations. Its mandate was to discuss further the major substantive and administrative issues arising out of the draft statute prepared by the ILC. The preparatory committee held a number of meetings between 1996 and 1998, which resulted in the formulation of the draft statute. Only a few provisions of the ILC original draft statute remained intact after that process. The ICC statute entered into a force on 1st July 2002, the first day of the month after the 16th day following the date of the deposit of the 16th instrument of the ratification. Before ratifying the statute, most states needed to modify their domestic constitutions and laws in order to comply with the obligations imposed upon them by the statute. Particularly, states were required to provide for cooperation with the court in terms of the investigation, arrest, and transfer of the suspects. However, many states' constitutions prohibited the extradition of their nationals, which is incompatible with the requirement of the statute. Many states decided to bring their substantive criminal law in line with the statute. So, the ICC represents a watershed in the development of the international criminal law. It is the first permanent international criminal court. The court has, for understandable reasons, got off a slow start by November 2008. Only three situations had been referred to the court by the states parties concerning a situation on their own territories, namely the Democratic Republic of Congo, the Central African Republic, and Uganda. A fourth situation in Darfur, Sudan, was referred to the court by the UN Secretary Council acting under the Chapter 7 of the UN Charter. And the International Criminal Court, ICC, or the court, is a permanent international court established to investigate, prosecute, and try individuals accused of committing the most serious crimes of the concern to the international community as a whole, namely the crimes under the jurisdiction of the ICC, which are crime of the genocides, crime against the humanity, war crimes, and crimes of the aggression. Some of the most heinous crimes were committed during the conflicts which marked the 20th century. Unfortunately, many of these violations of the international law have remained unpunished. The Nuremberg and Tokyo tribunals were established in the wake of the Second World War in 1948, when the Convention on the Prevention and Punishment of the Crime of the Genocide was adopted. The United Nations General Assembly recognized the need for the permanent international court to deal with the kinds of the atrocities which had just been perpetrated. The idea of the system of the international criminal justice re-emerged after the end of the Cold War. However, while negotiations on the ICC statute were underway at the United Nations, the world was witnessing the commission of the heinous crimes in territory of the former Yugoslavia and Rwanda. In response to these atrocities, the United Nations Security Council established an ad hoc tribunal for each of these situations. These events undoubtedly had a most significant impact on the decision to convene the conference which established the ICC International Criminal Court in Rome in the summer of 1998. So here this was the brief history and introduction of the International Criminal Court. So our next topic, we are moving on to our next topic.